intentional breach of contract did not constitute willful misconduct under the terms of the contract absent an intention to harm. In Peluso versus Tauscher, Kronecker, Professional Engineers, the court held that under the circumstances, an engineering company's failure to properly conduct a home inspection did not rise to the level of gross negligence. Where the plaintiff claims the defendant was guilty of gross negligence or willful misconduct, the pattern charge may be used. The jury should not be told that there is an exculpatory agreement between the parties, and it is suggested that the jury be required to render a special verdict as to which see PJI 1:97. Parties to a contract may agree to be bound by a shortened statute of limitations for all claims, including those involving gross negligence. An exculpatory agreement is a special defense which insulates a defendant from liability for ordinary negligence, while direct liability to plaintiff is triggered only by gross negligence. Defendant may be liable for contribution based on ordinary negligence only. Agreements exempting the owner-operator of certain establishments from liability for negligence are void. See Applique Die Cutting Company against 315 McKibbins. It is also found that where decedent paid a fee for admission to pit area of the automobile racetrack, the statute rendered the release void. Statute is inapplicable to release given to Racing Car Association and its beneficiaries in an application to be a licensed mechanic. So, statute inapplicable to plaintiff who entered raceway as member of pit crew and did not pay a fee to use the facility. The statute is inapplicable to retail establishment that rents and sells ski equipment. The user of volunteer tow truck crews present to work at a raceway is not a user of facility and not protected by the statute. A contractual limitation upon liability in pawn agreement is invalid in an action where convention or conversion is shown, but a limitation of liability to proceeds of insurance is valid. The third department has held that an owner cannot circumvent, that is, by inserting a provision into the lease that shifts liability by a lessee, by requiring the lessee to maintain liability insurance and pay premiums on the owner's behalf. Dunn versus Story Street Realty, Incorporated, the third department has determined that GOL Section 5-326 is not limited in application to the person or entity who actually pays the fee, but rather is applicable to an owner of or operator of a recreational facility who receives a fee, Williams versus Albany. The second department has concluded that to void a release of liability executed by a user of a recreational facility pursuant to GOL Section 5-326, the individual must have paid a fee for use of the facility. To be distinguished from exculpatory agreements are indemnification agreements. See Austro versus Niagara Norwalk Power Corp. 66 New York 2nd 674, 496 New York Supplement 2nd 410, 487 Northeastern 2nd 267, LaVac versus National Shoes Incorporated, 124 Appellate Division 2nd 352, 507 New York Supplement 2nd 293, PJI 2:275. In this case, however, there is an exception, and that exception is that there is evidence in this case as to the nature of the plaintiff's disability. If you find that the plaintiff was under a disability that limited their limited her ability to protect herself from injury, and that defendant knew or by the use of reasonable care should have known of that disability, then reasonable care on defendant's part required that she use such care as would be required for plaintiff's safety in view of plaintiff's disability. Bear in mind, however, that until the defendant knew of the plaintiff's disability or by the use of reasonable care should have known of it, defendant was entitled to assume that plaintiff was not disabled and would be able to use due care for her own safety and would do so. Hello?